The leak of a draft Supreme Court opinion.
The Supreme Court.
The court that dark money built.
Breaking news at the Supreme Court.
The landmark Roe v. Wade case.
A woman's constitutional right to an abortion.
My body, my choice.
And Leonard Leo, who really is responsible for helping Trump fill the Supreme Court.
A Supreme Court decision with dramatic consequences. The justices ruling 5-4.
You look at the decisions like Shelby County that attacks voting rights, and then you look at the dark money cases like Citizens United. It's not just us.
The court is not in order. This is Senator Sheldon Whitehouse, and welcome to Making the Case. I am joined today by Judge Nancy Gertner, a distinguished retired federal judge who was appointed to the District of Massachusetts bench by President Clinton in 1994. She is extremely well regarded among her colleagues, has taught at both Harvard and Yale law schools, and was chosen by President Biden to serve on his presidential commission on the Supreme Court. So, Your Honor, it's wonderful to have you here with us. Thank you for joining us.
It's good to be here.
So you've looked at the Supreme Court from the perspective of a federal judge for many years. What seems to have changed the most during your time on the federal judiciary with the Supreme Court?
Well, there are two perspectives here, two things that have changed. One is that this is a court that, particularly once it got to a 6-judge super conservative majority, disregards precedent, and disregards precedent at a pace that is extraordinary to me. I've written about Ruth Bader Ginsburg, and Justice Ginsburg was an incrementalist. The work that she did was over a 20-year legal career and then a multiple-year judicial career. And she believed in precedent and believed that legal change should be slow change. This 6-judge majority has been undoing precedent from the moment that they have gotten on the bench. And it's not just the ones that we know about, not just Roe v. Wade and the gun cases, but really, union dues cases, even civil procedure cases. It seems that everything that has been held dear to all of us that we teach our students for the past 40 years is up for grabs. And that I've never seen before. And then you add to that the fact that this majority then can pick the cases that it wants to review. And those cases are cases that set up an obvious agenda. Each one of the new justices, new and old justices of the 6, have cases that they've wanted to undo, and they're picking those cases. Then this is all apart from the issues of the shadow docket, which are the cases that they resolve on the papers without oral argument. In other words, they're doing all of this because they can, not because it's right, not because the law requires it, but because they can. And that's shocking.
Let's explore a little bit the picking cases problem, because I suspect that in your years trying cases in federal court as a judge, usually the plaintiff who came in with the case was a real plaintiff who had a real grievance and was bringing it against a real defendant, and you had a real, what the Constitution would call, case or controversy in front of you. It seems to me that a lot of these cases that end up at the Supreme Court are not brought by real plaintiffs. They're brought by advocacy groups who have found a plaintiff of convenience. They're structured to give the court the opportunity to pick them, and they're crafted with the support of flotillas of front group amici who come in to file amicus curiae briefs, what are called friend of the court briefs, to send the message to the judges what it is that the interests behind the litigation want. Is that a fair comparison? And did you see that in your time?
I never saw it when I was on the bench, and I never saw it at the Supreme Court. In fact, the pressure that I felt when I was a district court judge was always the pressure to duck. I've written about this. In other words, to say the case was, that someone didn't meet the statute of limitations, there was no case or controversy. The judges were mostly avoiding controversial decisions because they understood that they are not elected and that they have to deal with the cases that come to them that are real cases. Otherwise, they're outside of their lane. Otherwise, they're doing what Congress is doing. So no, during my time on the bench, I never saw that. The issue of standing, that's really what we're talking about, was litigated all the time, and the rules were strictly enforced. But it's not just a question of made up cases. The Masterpiece Cake person who actually was not harmed by having to do a cake for a gay couple, or the most recent one about the website where the person who was designing the website had never ever designed a website before, and she was describing a future injury. We never had future injuries, potential injuries, come before the court. These are cases that are contrived by advocacy groups and supported by legions of friends of courts, as you indicated. We never saw that on the bench, and I don't think that we saw that on the Supreme Court. In fact, just the opposite. The court ducked more than they took. This is a court that is aggressively seeking cases that they shouldn't.
In one of the labor union cases, the nominal plaintiff who was brought in by the advocacy group was actually put on the payroll of the advocacy group. So the whole thing gets a little bit peculiar. I call all of that faux litigation because it did not arise out of a normal, true contest between contending parties who've come to court to resolve their differences. Instead, it's just a constructed avenue to bring questions before a friendly court.
Well, and when you put together, so of the six, each of them have their pet precedents that they would like to undo. Most recently, Justice Thomas talks about setting aside New York Times versus Sullivan. And so he communicates in a dissent until the court went 6-3 in his favor that, he'd like to reconsider this 50-year-old precedent, at which point advocacy groups find someone to raise that issue. And now they're the judges who'll do it. But the speed with which they have undone American law is really chilling.
One of the tells is when the advocacy groups come into the trial court where you would be the judge and say, Your Honor, I'd like to lose and as quickly as possible, please.
Right.
That's not something you saw much of in your time on the bench, I suspect.
No, there certainly were people who brought cases and didn't try very hard, didn't move for class certification or didn't do very much, lost, and then would go to give a press release on the steps of the courthouse. But this would be losing for the purposes of racing to the Supreme Court. By the way, you had to add to the mix the numbers of cases that went from district courts directly to the Supreme Court, bypassing the Court of Appeals. Again, these are extraordinary measures. People have talked about judicial activism where you have an agenda and you impose it on the cases. You can't impose very much when you're sitting back waiting for the cases to come to you that are real cases. But if you're reaching for the cases and you're inventing the cases and you're reaching for the lower court cases, you can impose an agenda.
You were one of the people that President Biden selected for his commission on the Supreme Court. At the end of that process, on the day that the Supreme Court Commission's report came out, you and Professor Tribe released an op-ed that looked a lot like what you might call minority views. Tell a little bit about that process and how that was and why you felt obliged to write the op-ed on the date of the report when both of you were members of the commission.
This was the commission that President Biden set up to do a deep dive into the Supreme Court, the ethical issues of the Supreme Court, the size of the court, term limits, all of that. And it was extraordinarily balanced. We were not tasked with coming up with recommendations. We were tasked with laying out what the issues were. So there was nothing to dissent from because there was no position that the commission was taking as a whole. What Professor Tribe and I wanted to make sure that our views were in the report and that they were credibly stated. In other words, it's easy for a report like this to say, one side says X, but of course, everyone else disagrees. And it was not written that way. Our views and the views of many others on the commission were credibly laid out. And the opposing view, in my case, we were talking about the size of the court. But there were no recommendations. And when the report was issued, everyone was free to say, here's our recommendation. And that's what we did. We did an op-ed in the Washington Post the day that the report came out.
A lot of the issues that I raised to the Presidential Commission were completely overlooked and ignored in the final report, but you and Professor Tribe did address them in your op-ed. So thank you for that. Shifting to fact-finding. You were a district judge. You had trial responsibilities. You had to evaluate the credibility of witnesses, look at the record before you, and find the facts. And that was the key central role that a district court judge has. Then your work can be reviewed by the Circuit Court of Appeal and ultimately by the Supreme Court. But the most challenging standard of review is to overturn what you found about the facts. And one of my contentions is that the recent Supreme Court has propped up a lot of its decisions with what I consider to be false fact-finding. For sure, not found in the record below, not supported by findings of record from the courts below, and in many cases invented at the Supreme Court level and at a minimum highly debatable, if not outright false. As a district court judge who specialized in fact-finding and who was used to having your fact-finding respected at the appellate court level and indeed often sent back to you for better fact-finding if they found fault, tell me what you think about this new behavior of the 6 justices on the Supreme Court propping up their decisions with facts that they have essentially manufactured.
Well, there's a reason why the district court has principal responsibility for fact-finding. And the reason is that you see the people, you hear the testimony, you make the credibility judgments. It's like a funnel. We get to see a great deal of information. You funnel it into fact-finding decision, and you're reviewed on, and the standard is called an abuse of discretion, which means not that someone sitting in my shoes just plain disagreed with my fact findings, but a view that I have a range of facts that I can find from the record in front of me. And unless I'm completely outside of that range, my fact findings are respected, and credibility is a significant issue. Every other court, the Court of Appeals at that point and the Supreme Court, takes as a given my fact finding. They can apply different standards of law, but they take as a given my fact finding. When the court, the Court of Appeals or the Supreme Court finds facts on their own, they're basically bypassing witnesses, credibility determinations, the oath. They are making things up. This is nowhere more clear. There are 2 cases that come to mind. One, of course, is all the cases in which, Dobbs in particular, in which the court selectively found historical references to support its position, when in fact there were contrary historical references, which would have said something totally different about the state of abortion during colonial times, the state of abortion post-Civil War. It's not to say that their original approach is correct, but they are clearly reaching for a version of history that was dramatically contested. There's a judge, Judge Carlton Reeves in Mississippi, who said that the next time he has a case that will require an original interpretation of the Constitution, he's going to hire a historian on the court dime so that this can be a more elaborate, more substantial historical record. I'm not sure that would stop this court. They would find other historians. So that was one. And the other were the rigorous findings that were made by Judge Burroughs in the affirmative action case out of Harvard University. She had, I think it was a month-long trial. Her decision was over 100 pages. She digested the record, and the court ignored it. Now, in that situation, the court was imposing a standard, again, overturning precedent, a standard which no one had imposed before. But one can imagine in a situation like that if you're going to undo the precedent and impose a new standard, you send it back to her to find facts in the light of that standard. I mean, what you see in the things that we're talking about here is a Supreme Court that is arrogating it to itself an enormous amount of power. And given how the issues that they're prepared to rule on, that is incredibly dangerous. Incredibly dangerous.
If they stuck to the facts that are properly developed through the judicial process, those facts would have first been offered by one party and scrutinized by the other party, who has the right to argue back in the courtroom, and then the judge would have made a determination with that adversary scrutiny having taken place about what made the most sense and seemed most consistent with the evidence. And then it would go up to the Court of Appeals, which would provide a second level of review. And if the judge got it really wrong, then you'd be able to go back, send it back to the judge, and order the judge to redo the factual analysis. And by the time it got up to the Supreme Court, you'd have a very robust and specific factual record, and not just them going off onto the internet to find stuff to back up something they want to decide anyway.
And it would have been tested at various levels.
Yeah, exactly.
It would have been tested. These are not tested, but it also is, as I said, in a democratic society, we have the most powerful Supreme Court in the world, whose statements define, the last word on constitutional matters. And so for a court like this to act so completely out of lane is very troubling to a democratic society.
Does that mean there's a separation of powers component to allowing the judiciary to find facts the traditional way rather than letting the court of final appeal on its own, without any scrutiny or testing of the facts, be able to make them up?
Whether there would be a constitutional challenge, I doubt, but certainly there is a separation of powers issue here. When in one case after another, the court is undermining administrative agencies' power, undermining the power of lower courts and courts of appeals, and arrogating power to itself. What Professor Tribe and I talked about in our op-ed, we talked about expanding the court, and the reason was severalfold. One is this was a court, people talk about this as packing the court. We believe the court has been packed, but packed by essentially Donald Trump and packed by Senator McConnell, which is not giving Merrick Garland a hearing under Obama, which was extraordinary, racing through to get Amy Coney Barrett confirmed, within a month of Justice Ginsburg's death, ceding the selection of Supreme Court justices to the Federalist Society and to a handful of people, and essentially getting 3 appointments to the Supreme Court, which is extraordinary for any given president. On top of that, they are younger, so that this super conservative majority is baked in for decades and decades to come. And it was as a result of unorthodox methods in the Senate.
So that's a pretty good description of how the court was packed, I would contend, by special interests behind Trump and McConnell and the Federalist Society, who were spending hundreds of millions of dollars on their project. But once that's been done, and now you have these justices that have been chosen sitting on the court, they're not necessarily going to know exactly what they're supposed to do. So what I have noticed is that flotillas of amicus briefs from advocacy groups that aren't real companies. They don't make a product. They don't perform a service. They're not the American Medical Association. They're just groups that are set up for this very purpose, to hide who's really behind them and write briefs and be mouthpieces. They show up in flotillas of 10 or 12 at a time. And I doubt you ever saw that in your courtroom, and I suspect you might have been a bit intolerant of a group that came in that wasn't a real group and couldn't explain who they were fronting for in your courtroom. Is this new behavior, this flotillas of front groups effort?
The considerable effort to bring that to pass is certainly new, although there have always been amicus briefs that the ACLU would write, that American Medical Association would write. They were not contrived groups. They were groups that actually had an interest in the area. This is a campaign funded in ways that we've never seen before. But it's also, you have to sort of put the pieces together. So there are 3 justices, Gorsuch, Barrett, and Kavanaugh, who were selected for what they believed in, as opposed to in the past, for the most part, presidents would select justices for what, who had not expressed themselves on 5 or 6 points. They were easier to confirm. These, because of broken confirmation process, were selected in direct proportion to what they did believe in. And they've rewarded that selection process by delivering on those beliefs. That's never happened before. There's a classic view that, you put someone on the bench and they change. They begin to realize how much the seriousness of the job. Then you add to that the views that the justices expressed in there before they became justices and are now implementing on the bench are supported by, as you described, this flotilla of interest groups.
I think your phrase contrived groups is excellent as a descriptor.
Right. I don't want your listeners to think that this is a technical issue, whether or not the group is real or whether or not the group predated this case. But it matters, because if the group was invented for the purposes of the litigation, then the litigation process becomes a kabuki ritual, becomes essentially an empty gesture. You're not deciding the issues that are percolating up to you in society. You're picking the cases that you think are important and the issues that you want to opine on. And you're doing it even if it means throwing out 50 years of precedent.
So one thing that the contrived groups are being subjected to is more disclosure. The reports of the Judicial Conference have included a report from one of its committees that they intend to go forward and require better disclosure of who's funding, who's behind these flotillas of front groups, which takes us to the question of what role the Judicial Conference has in dealing with ethics issues for the federal judiciary. What was your experience with them? Are they trustworthy, creditable, experienced? What should their role be?
That's a complicated question. Not just what should their role be, what should it be, but recognize that the Judicial Conference is composed of the chief justices of each of the courts, and you become chief justice essentially randomly. It's a seniority position.
Yep.
So Justice Roberts can't control the membership of the Judicial Conference, but Justice Roberts controls the membership of committees.
Yep.
And I don't know whether you know this, Senator Whitehouse, but I was on the bench for 17 years. I applied for every Judicial Conference committee in my field of expertise, criminal law, criminal procedure. Every time I raised the rules committees, I would raise my hand. First Circuit was a small circuit, and usually each of us were on multiple committees over the course of a judicial career. For almost 8 years of the 17, I was not selected for any committee, notwithstanding my application, notwithstanding that I'm a worker. Finally, in year 9, I get a call that I'm on, wait for it, the IT committee. And when I got to the first meeting of the IT committee, there were 8 new members, all of whom had been appointed by Clinton, and all of whom had never been put on any committee before. So long as Justice Roberts is able to control who's on the committees that do the rulemaking for the Judicial Conference, then the result, it seems to me, is predictable. The Judicial Conference certainly could do more about an ethics code for the Supreme Court, but unless Justice Roberts is behind it, that won't happen.
One of the things that they're looking at is secret, all expenses paid vacations from billionaires to Supreme Court justices. How many of your district court colleagues and circuit court colleagues were getting secret, all expenses paid vacations from billionaires?
Well, it was not possible. And that's actually something that people haven't talked about. People talk about we need a new ethics code for Supreme Court justices. There's a bar on honorarium, speaking fees. And the statute says you can't take a speaking fee, but you can get necessary and reasonable travel expenses. What Justice Thomas has been doing is doing an end run on that bar. No, you can't pay me for the speech I just gave at the Koch brothers dinner, but man, you can give me a lavish trip, a private plane, luxurious accommodations. The notion that the Code of Ethics clarifies what necessary travel expenses means and says that it really has to be reasonable, and anything above that is effectively compensation, which you're not allowed to get. Now, the justices are technically not subject to the Code of Conduct, but you didn't really need the Code of Conduct to make it clear that what Justice Thomas is doing violates the honorarium statute, because even the statute says the expenses have to be necessary and adequate to the job. I traveled economy. I spoke regularly in China and spoke on women's rights issues and in Vietnam. I taught at Yale Law School every week. I took Amtrak. The other judges were invited. They took Amtrak. Justice Thomas went to a ceremony at Yale and took a private plane. The rest of us understood what the honorarium bar meant. The rest of us understood what the disclosure rules meant. It is extraordinary that he did not.
So let's wrap up with my invitation to you to make the case briefly, like summation, about why we need to reform the Supreme Court and what are the reforms you think are most needed.
The Supreme Court, as I said, is the most powerful court, high court in the world. It has more authority, more final authority than any court. It's also the only court in the world with no term limits. And it's also the only court in the world with no ethical code explicitly for it. There has to be an ethical code. There needs to be term limits. And in my view, the court has to be expanded. There's nothing magical about 9. It's been 9 justices for a long time, and there are 10 circuits. It has to be expanded. It has to be expanded precisely so that every president has an opportunity to appoint at least 1 or 2 Supreme Court justices. Again, given their power, we have a super conservative majority locked in for decades, selected improperly, in my view, and doing things that are improper, again, in my view. So change has to take place in numbers of fronts.
So Judge and Professor Nancy Gertner, President's Commission on the Supreme Court member Nancy Gertner, thank you so much for participating in making the case and for your candor and forthrightness.
Thank you.
Come on back to the next episode as we continue making the case.